Judgment in the appeal of the Queen on the application of Sturnham against the Parole Board of England and Wales.
Lord Mance will announce the decision of the court.
This is another case arising from the existence in this country from 2005 until 2012 of sentences of imprisonment for public protection, IPPs. An IPP could be imposed when the sentencing judge concluded that there is a significant risk to members of the public of serious harm occasioned by the commission by the offender of further specified offences. The judge would then fix a period commensurate with the offence itself, the tariff period, after which the offender would remain in custody until the parole board was satisfied that it is no longer necessary for the protection of the public that the prisoner should be confined. The essential question is whether the tests for imposing an IPP and for release by the parole board are to be regarded as the same despite their different language. Mr. Sturnham submits that they are. The parole board says that the difference in language represents a potential difference in substance and result. There is a secondary issue as to whether in any event the parole board misdirected itself. The Court of Appeal accepted the parole board's case on both issues. Mr. Sturnham was himself convicted of manslaughter after a fight outside a pub in which he punched a man who fell and hit his head on the ground. The tariff imposed was 2 years, 108 days. That expired on 19th May 2009, but Mr. Sturnham's first parole board review was only on 10th May 2010, a year later, when he was not released, although he since has been. This court has previously dealt with the damages to be awarded for the undue delay in holding a review until 10th May 2010, see 2013 UKSC 23. It now has before it Mr. Sturnham's further application for permission to appeal in respect of the test actually applied on 10th May 2010. The court grants the application for permission to appeal, but dismisses the appeal in a judgment given by myself. The reasons are that under the 2003 Act, IPP was a new form of indeterminate sentence based on offending either of a kind for which a life sentence was not available or not of such seriousness as to justify a life sentence. Sentences of IPP were fitted into the pre-existing framework established for mandatory or discretionary life sentences, under which the criteria for imposition of a discretionary life sentence were broadly the commission of a very serious offence and a conclusion that the offender was a serious danger to the public and likely to remain so for an indeterminate period. However, the suggestion in this connection in Ex parte Bradley in 1991 that the likelihood of further offending should be assessed by a criterion of mathematical probability is unsound. A test of good grounds would be more appropriate. In imposing a discretionary life sentence, the court thus makes, at least in part, a predictive judgment as to the future risk that the offender will pose at the end of the tariff period. In this connection, it's difficult to square the reasoning in the Queen against Nicholas Smith 2011 in this court that no such predictive judgment is involved when imposing a sentence of IPP without other case law, including case law at the highest level, such as Walker 2009 in the House of Lords, or even to see why the case of Smith needed to address that point at all. The reasoning in Smith is thus questionable, but since it was not challenged on this appeal and is not ultimately decisive, no more need be said about that. The test to be applied by the parole board is not the same as the test applied by the sentencing judge when imposing the sentence of IPP in the first place. The tests are in their terms and substance and in their default position different. By introducing IPP into the framework applicable to discretionary life sentences, Parliament must have intended that release from a sentence of IPP should be subject to the like test as release from a discretionary life sentence. There's no reason why a statutory scheme should not involve a higher threshold for imposition of a sentence of IPP than for continuation of custody post-tariff. The European Convention on Human Rights does not require a different result. Strasbourg case law accepts a sufficient causal connection between the imposition of a sentence of IPP and the deprivation of liberty in the post-tariff period when release is contingent on the offender demonstrating to the parole board that he no longer poses a risk. As to the secondary issue, there was no basis for interfering with the decisions below, that it is not shown that the Parole Board wrongly took into account directions by the Secretary of State about the test to apply, which it is accepted that the Secretary of State had no power to give. The appeal is therefore dismissed.
Thank you. The court is now adjourned.